Welcome, everyone. Good afternoon. Thanks for joining us. It's great to pretend to be able to see all of your faces right now. We have what we hope will be a very interesting webinar for you. If I could see your faces, I'm sure I'd be telling some of you to get haircuts and get your kids off of video games, give your dogs a break, stop watching TikToks. It's not apparently meant for our generation, my kids tell me. For those of you who I don't know, my name's Adam Carr. I'm a partner in the Labor and Employment Group at O'Melveny. Also from O'Melveny, joining me is our great partner, Aparna Joshi, who's based in our DC office. And also with us is Janine Tang, who is the General Counsel of Participant and also an O'Melveny alum. I've had the privilege of working with Participant now for about 15 years. Some of their greatest films out there are some ones you would know and ones that I've enjoyed over the years. Some of them that have been the most impactful, and you can just take a look here and see them. Just Mercy is a fantastic film that I would sort of add to your binge watching agenda for during this pandemic. RBG, Wonder is a tremendous family film that we've all watched with the kids, and of course we're here today to talk a bit about Contagion. Participant is a very unique company, and Janine, to start this off, if you could just tell us a little bit about Participant's business model. It's not like most film production companies.
Yeah, so thanks, Adam, for inviting me today and for the warm introduction to the Participant films, some of which here are also some of my favorites, including Roma, which I'm going to highlight as one that I'd like everyone to take a look at. It's on Netflix. But in answer to your question, yeah, Participant definitely has a very unique business model. Jeff Skoll founded the company 15 years ago, so right around the time that you actually started working with the company. And Jeff's North Star principle was and is to create content that sparks social change and engage audience in the world's most pressing issues. And one of our main mantras at Participant, which is actually plastered on the walls, if we were all back in the office, you'd be able to see it, is to inspire, empower, and connect. And our view is that storytelling is a very powerful tool to support and pursue positive social change in the world, because it brings social issues out to light and makes them accessible and understandable to a larger audience across the globe. Many of our stories tell the tales of ordinary people who see injustice in the world and seize their individual power to make change. And a perfect example of that is in Wonder, where one little boy can create a difference in a whole community of people. So to your point, Adam, in terms of how our business model is actually different and unique from a quote unquote traditional Hollywood company, it's that we believe in a double bottom line. So that social impact, these messages that are brought out through our storytelling to impact social change, is equally as important as the financial and the revenue bottom line for the company. And I'm really proud to say that a lot of our peer companies view us as trust accelerators in the business.
Turning back the clock just to 2011, at that time it had been almost 90 years since the United States had experienced a pandemic that had affected the nation in a material way. And yet your Participant decides it's the right time to release Contagion, a movie which depicted a fictional pandemic. Janine, seeing as how in 2011, and again, been almost a century since the United States or the world had experienced a pandemic, how does Participant decide to make a movie about a pandemic? And some of you may have said that you guys had a crystal ball. Before we jump in and I ask you some additional information about the film, let's run the trailer for Contagion so that everybody can see it.
It was a groundbreaking ceremony for a new factory.
Did she mention seeing anyone who was sick? Anyone on a plane at the airport?
No, she said she was jet lagged.
The average person touches their face 3 to 5 times every waking minute. In between, we're touching doorknobs, water fountains, and each other.
Beth. Mom? No, go up to your room, honey.
So we have a virus with no treatment protocol and no vaccine at this time.
You had a seizure this morning, Beth.
Does she have a history of seizures
No.
allergies?
As of last night, there are 32 cases.
Unfortunately, she did die.
Right. Can I go talk to her?
Mr. Amoff, your wife is dead.
What are you talking about? What happened to her? What happened to her?
Is there any way someone could weaponize the bird flu? Is that what we're looking at?
Someone doesn't have to weaponize the bird flu. The birds are doing that.
Watch this. It's transmission, so we just need to know which direction.
On day one, there were 2 people, and then 4, and then 16. In 3 months, it's 1 billion. That's where we're headed.
They're calling out the National Guard. They're moving the president underground. People will panic.
Get away!
It will tip over.
The truth is being kept from the world.
Cook your samples, destroy everything.
Hello. I need you to get me the names of everyone who serviced this room. It's an emergency.
You can't panic now.
I know.
I'm gonna get you home. I got people too, Dr. Cheever. We all do.
Don't talk to anyone. Don't touch anyone. Stay away from other people.
Get back in your car. We're not sick.
It's figuring us out faster than we're figuring it out.
It's mutated.
So again, this film comes out 9 years ago. Janine, can you give us the backstory on the film?
Sure. So, Jeff Skoll, who I mentioned was the founder participant, has actually always been at the forefront of being interested in fighting pandemics. And actually in 2009, he founded an organization called Ending Pandemics, which still exists today and provides scientific, technical, and catalytic funding to find outbreaks faster in emerging disease hotspots. So Dr. Larry Brilliant, who's an epidemiologist who spearheaded the successful global eradication of smallpox, was the original CEO of that organization and still sits on the board. So when we were making the film, we consulted with Dr. Larry and other expert epidemiologists, such as Dr. Ian Lipkin at the Columbia University, who's also an epidemiological professor and served as the film's main scientific consultant. And one of the things that Dr. Larry said at the time that the film was being produced is that people didn't really seem to recognize the fact that there was going to be, or could possibly be, another kind of contagious outbreak, such as smallpox. And so they kind of set out to make that a reality for people to see.
So of course, companies around the world are struggling with what to do now that restrictions are beginning to ease from the government and otherwise. How is participant, as just a general manager, managing a potential reopening?
Yeah, it's a great question. And I guess I would say, at the forefront of our reopening discussions is the fact that we have this long history and long involvement with supporting eradicating infectious diseases through Jeff Skoll and his mission and his interest. So at the forefront of all of our discussions is really promoting the health and safety of our employees, but also the community at large. So we are taking things slowly. So far, we've organized a task force internally at the company, comprised of various departments that would be involved in a reopening, such as HR, operations, facilities, finance, to really analyze, plan, and prepare for that reopening. And we're really just looking at every angle that we can to both promote health and safety and obviously to comply with law. And we are consulting as well with the school organizations so that everybody's on the same page about how to proceed.
Thank you. Let's shift gears again and talk about some of the danger areas that businesses should be thinking about as restrictions are eased. So as I think about these issues as a labor and employment lawyer, it strikes me that there's really two things to think about. I mean, first you have to think about the the just sort of general practical legal mechanics of like how do you go about opening, and then second, with our risk mitigation hats on that we all have as lawyers, what should we be thinking about? How do we avoid legal risks? What are the areas that we should be thinking about as we do this? Aparna, would you mind talking to us a little bit about the practical legal mechanics?
Sure, Adam, thanks so much. Yeah, when we talk about the practical mechanics of reopening and staying open, there are obviously 1,000, probably 1 million details that we all need to work through. But we don't have time for that today. And what I thought would be useful is to talk about what I consider sort of 4 pillars of reopening and staying open, because that, of course, is the goal. The first pillar here is staying up to date on the federal, state, and local guidance. And this is a little bit more difficult to do than it may seem, because this is changing constantly. And there's a lot of variation between states, within states. So it's not just the federal and state guidance, but also the local guidance. Staying on top of orders from governors, from mayors, from city and county council is critically important and is in and of itself sort of a full-time job. The next piece, or the next pillar that I see as sort of a foundational approach to opening the workplace again is convening a reopening team. So as Janine mentioned, a task force. Consider, or at least employers should be considering identifying a COVID-19 workplace coordinator, a point person, and a team of people who will be addressing or developing the reopening plan, and who will also address COVID-19 related issues as they arise, because of course they will arise. And as Janine mentioned, the team should cover all aspects of your business. So legal, HR, operations, as Janine mentioned, finance, all of them need to be on the same page and working together. The third pillar is developing that reopening plan. And that should be done obviously in advance of having your employees come back to the workplace. And there's a lot to think about there when we think about who is coming back, what they're going to be doing, when they're coming back, how we're bringing them in the door. So things to consider without getting too bogged in the details, but of course that's what drives all of this. Consider whether the employees are able to perform their work remotely. It sounds like the vast majority of folks on this webinar have employees working from home. Consider also a phased approach to opening the doors. It doesn't have to be all at once. Consider a gradual approach, or staggered start times, so that we can reduce the population density in the workplace, because of course the distancing is one of the most critical factors that we can utilize to keep everyone safe. And then also consider whether you're going to implement a system or a symptom questionnaire and temperature checks, for example, something where employees are going to certify or acknowledge that they are not experiencing symptoms and can come into the office, or if they are experiencing symptoms, to have them stay home. The other piece that should be part of any reopening plan is, what do you do when employees become sick? Hopefully that doesn't happen. It is more likely than not to happen at some point. So having a plan in place about sending sick employees home, a protocol for sanitizing their workspace, and notifying a procedure for notifying those that they came in contact with. So all of that should be part and parcel of the reopening plan. And then finally, the sort of fourth pillar of this is assessing the physical and procedural changes that will be needed to make to the workplace. And that can go from the engineering controls that OSHA identifies, things like plexiglass separators and improved air filtration, to what Adam was talking about, earlier when we were talking about, markings on the floor in elevators. This is how far apart 6 feet really is, because I think we can all say that, but if I had to guess how far is 6 feet, I might not quite get there. So having those kinds of reminders, signage, reminders to wash your hands for 20 seconds, respiratory etiquette, things like social distancing, all of that will be important to remind employees of. This is a brave new world in a lot of ways. And so making this become the new normal will take some educating. And the CDC has posters for best practices available. So those two should be implemented. I will also just add one more piece of this, which is, and it's really part of your reopening plan, but it is a communications plan. And I think that that is enormously critical, because like the film Contagion, I think the tagline was, nothing spreads like fear, and that is absolutely true. And so one of the things that employers can be doing to help avoid that is providing transparent and frequent communications to employees about health and safety being a top priority, about all of the practical changes that are being put in place, the solutions that are being put in place, including the deep cleaning, all of those things that you're doing. And then also as a way to educate employees about the things that they should be looking for in themselves, right? Their symptoms. So identifying what the CDC says are symptoms, having them monitor themselves, because the best way to keep the business open is to keep employees who are sick at home so that they don't spread it to others. So that's what I would sort of identify as the pillars of reopening. Again, Adam, there are 1,000, as you know, so many details to work through, but as if you think about it sort of in this fashion, it'll help organize it all.
In addition to just the practical mechanics of trying to open up a workplace again, we also have to think about litigation risks that can come about. Without getting too bogged down in this, what do you sort of see as like the top 3 litigation risks in this area?
One of the things with communications, of course, is they can be used against you in litigation. So, of course, when issuing your communications, have them vetted by counsel before sending them out. So, litigation risk number 1. The litigation risks that I see as sort of the top 3. Obviously, there are going to be a lot of new litigation areas here and potentially novel litigation areas here. But I think something that we can all expect to see is an uptick in the discrimination and retaliation claims, especially based on national origin and age and disability. And these can arise in the context of administering leave policies, administering the COVID-19 health screenings, recalling or rehiring. I think we can also expect to see an increase in claims of failure to prevent discrimination and harassment by coworkers, a failure to provide accommodations. And so what are some of the things that we can do to try to mitigate those risks? First of all, none of this is really new. We would do what we always do, right? Implement your return to work protocols in a fair and non-discriminatory fashion. So use legitimate non-discriminatory reasons, for example, seniority or operational needs when you're making those decisions about who's going to come back into the office. Document that. And also, be sure not to impose different standards on different groups. For example, don't impose more stringent standards on employees who are over age 60 or on pregnant employees returning to the office. The EEOC, in terms of preventing discrimination and harassment by coworkers, the EEOC recommends reminding employees about illegal discrimination and reminding supervisors about their role in preventing and stopping and reporting all of that. And then finally, with disability accommodations, I think, again, all of it stays the same. It's what we've always done. Requests for reasonable accommodation should be analyzed on a case-by-case basis, but there are a couple of things to bear in mind that might be a little bit different now. The first of which is you may have employees who are asking to work from home indefinitely as an accommodation because they have an underlying condition that makes them more vulnerable to COVID-19 that qualifies as a disability. If they've been working from home for some period of time during this pandemic, that may be a factor in ascertaining whether or not this is an undue burden or whether it's a reasonable accommodation. The other piece here that's a little bit different is the EEOC has recognized that what may have been a reasonable accommodation prior to the pandemic, as a result of the economic impact on employers, may no longer be an reasonable accommodation. It may be too costly. And if that's the case, employers should be looking at low cost or no cost options that may be able to serve as an accommodation. We can also expect to see retaliation claims spike because we'll be hearing more, I think, from employees on workplace safety concerns. And as a result, that, depending on the circumstances, may constitute protected activity. So employers should exercise caution and should not retaliate against employees for raising good faith workplace safety and health concerns. The second area that I think we're going to see more of is litigation based on working conditions, personal injury, and wrongful death. And we have already started to see those kinds of claims coming up against companies like Walmart, Amazon, McDonald's, claims that involve failure to provide adequate safety measures in the workplace, those sorts of things. And so, again, one of the best things that employers can do to try to mitigate that risk is to try to implement as much as feasible the guidances from the various agencies and to apply those policies and procedures consistently in order to both keep your employees safe and also protect yourselves from future litigation. And Adam, I think the other sort of the third of the top three would be class actions. What do you see as the kinds of class actions that we should be anticipating, and how can employers mitigate that?
Yeah, so I think we're going to see a lot of class actions in this space. As an initial matter, there's obviously no shortage of lawyers who are interested in bringing them, particularly in the states like California. You also have a really unique set of circumstances, and just in terms of how this is all developed, right? So employers oftentimes will, form committees and plan things out, and everything will be done in advance. And we found ourselves in a very unique circumstance, in that many employers were forced, literally overnight almost, to switch to a remote work environment, and to pivot in a way that that they hadn't anticipated having to do before. And I think there will be some claims that will arise from that. What do I see as most likely? I think you're going to see class action claims related to the reimbursement of expenses for non-exempt employees, particularly in states like California, where an employer has an obligation to do so. I think they're going to come in different forms, right? But like a share of the expenses that an employee is incurring as a result of having to work at home. I think you're going to see things that are related to, frankly, an inability on the part of employers sometimes to regulate what's happening when people are working at home. So failure to provide, meal breaks, working overtime. In a traditional working environment, there are lots of controls. At least at the first step of this, there may have been fewer of those. I also think you're going to have situations where there may be claims of exemption status, right? Where an employee was exempt from overtime because they were, for example, an outside salesperson. But because of what's happening right now, they find themselves, due to a shelter-in-place order, working from home. And I think we're going to see a lot of those types of claims. I also think that as we start to reopen, we're going to see claims, and there's ways to mitigate those risks, right? So, for example, a lot of employers are going to implement temperature checks. A lot of buildings are going to implement temperature checks. Employers are going to implement, COVID screening. It'll be important, particularly in certain jurisdictions, to compensate employees for the time spent going through that process. We've seen cases in the class action context, in the wage and hour context, related to, for example, bag checks while people are leaving the premises to make sure that they don't have any merchandise on them. I think you're going to see those types of claims in this context as well. So really thoughtfully sort of planning the return to work and how you're going to compensate people in this sort of new environment, where there's some gating mechanisms that people have to go through before they get into the workplace will be important. The first question is to you, Janine, which as a litigator, I can actually appreciate the ambiguity in this question. But the question is, will there be a sequel to Contagion?
Yeah, it's a very good question. There isn't a sequel currently planned, but I will say, the way we view content at Participant is that it has a life. It has a life beyond the moment that it was released, and can be used as a tool to be viewed in different times and different eras. And hopefully, now that everybody has or will 70% rewatch the film, we'll be able to learn some lessons and see that it's not just art imitating life, but that the film actually sets forth science that hopefully we can all learn from and move forward from.
The next question we got is, and Aparna, I'll direct this one to you. Our company is planning to phase return to work and has identified anyone who is most vulnerable as the last phase to be able to return. They identified people over the age of 60 for this last phase category. Is this a problem?
So I think it is potentially an issue. The EEOC has issued guidance that unilateral decisions like that, where you're treating employees over age 65 differently, treating pregnant employees differently, whatever, based on whatever category of risk, that those unilateral decisions are potentially going to be a problem. Now, one of the things that you can do, as I mentioned, is in your communications, identify for folks what the various risk categories are. So if they want to raise their hand and say, I'm over 65, I think I need an accommodation because of X, Y, or Z issue, then that conversation can occur. But I would be a little concerned about taking a group like those who are over 65 and having them be the last to return. Adam or Janine, I don't know if you have additional thoughts.
Yeah, I agree. One other question is, how should employers deal with employees who just say they won't come back until there's a vaccine? Like they're not in a vulnerable category. They're not claiming to be. They just say, I'm not coming back to work till there's a vaccine.
So I think that's a very fair question, and one that we should certainly expect to see. I think that from an employee relations perspective, it's worth a discussion. It's worth a discussion with them to see if there are things that you can be doing that can help alleviate their concerns. And if you ultimately can't get there, then it's worth a discussion about whether this employee is eligible for some kind of leave, and maybe an unpaid leave of absence, something along those lines, or if they've been working from home, whether they can effectively continue to work from home.
Yeah. Let's talk a little bit about situations in which an employee is refusing to comply with whatever requirements the employer has put in place, right? Be that a temperature screen, wearing a mask, social distancing, anything like how should employers treat that? Should it be the same as they treat any other employment rule?
Yeah, I think it should be. I think that, your policies and procedures are your policies and procedures, and you should be addressing these policies just as you would infractions or refusals to comply with other policies. Obviously this is a brand new approach and a brave new world, all of that. So your, the method by which you're potentially giving warnings or discipline, et cetera, should follow what you have done in the past. But I think, as always, the discipline should match the infraction. But I think, you have the ability. If someone is refusing to social distance or refusing to wear a mask, then you do have the ability to discipline them.
We got a hypothetical, which I'm happy to answer. Employee caught COVID, maybe at work. His mom and dad caught it, maybe from him, and dad died. Can we be held liable? So Aparna, you touched on this a little bit, but these are the issues that are presently being litigated. So in fact, some of these questions are in active cases. There's a recently filed case in which an individual caught COVID, took it back, and a family member passed away as a result of it, and they're seeking to establish liability in that context. It involves a lot of questions of duty and causation and trying to figure all of these things out. So the practical answer is these may be very challenging cases to prove, but they are certainly being brought in this context. Aparna, I don't know if you have anything to add on that.
No, I think that's exactly right, Adam. I think that part of it will depend on where you are. Obviously the facts of the case, but also what jurisdiction you find yourself in.
All right, well, thank you everyone for joining us today. If any of you have any questions, feel free to email or call Aparna or me. We'd be happy to answer those.
Thanks for watching Lawdition. Continue watching programs that will challenge your thinking, while getting to know the best lawyers in every field as they share their insights, and all while satisfying your CLE requirements. When lawyers audition for new clients, everyone wins.